Welcome everyone to another Facebook Live Legal Edition. We've really enjoyed doing all of these and interacting with everyone. We have some special guests today. We have Shane Norris. He is the UAR Forms Chair and also legal counsel for Summit Sotheby's. And so we want to welcome Shane. Thanks for joining us, Shane.
Thanks, Craig. Good to be here.
And we also have Peter Christensen, former legal counsel for the Utah Association of Realtors and current CEO of Utah Central Association of Realtors. Thanks for joining us, Peter. And Peter is also a member of the Forms Committee. So he sits on the forms and he helps evaluate them and gives valuable feedback on them. So thanks, Peter, for joining us. So I'm your host today. We're going to talk about some important forms. And these forms that we're going to talk about, the feedback that we're getting is that the current versions are being used in many transactions and that there's some complications arising out of them. So we wanted to simplify them. Frankly, these modifications have been in the works for months now. But when the kind of the shutdown related to COVID-19, we didn't want to disrupt any other aspects of the real estate transaction. So we decided as a Forms Committee to hold off on introducing the changes. And so now we feel that it's a good time to unveil them, to simplify the transaction. So feel free to chime in with any questions you have, comment them. We're gonna turn the time to Shane and Peter. I'm gonna pull up the forms and we'll talk about how these interact, and I'll ask some questions that maybe what the Forms Committee was thinking when we discuss these. So we'll jump right into it. We'll start first with the subject to sale of buyer's property addendum. Now, before we even dive into the changes and the issues here, Shane, when would a buyer typically use this form? I know that sounds pretty basic, but when would a buyer need to include a form like this as part of their offer?
No, I think that's a great question to start off with, because you sort of have to go back in time. The last iteration of the real estate purchase contract that was approved by the Utah Division of Real Estate included new language, section 2.2, that required the buyer to disclose whether or not they needed to sell a property, essentially, in order to purchase this property that we're going to deal with in the real estate purchase contract. And language that was included in that there would be included with this, if they mark that it is subject to the sale of a property, that they would include a subject to sell addendum in lowercase, but that there would be some sort of addendum that would be attached dealing with the sale of the buyer's property. And so UAR created the original subject to sell addendum right around the same time that the real estate purchase contract was released in the new form, to give basically an addendum that can be used in conjunction with 2.2 when it was marked in the affirmative. And so basically the concept is, if I have to sell my house in order to buy this new house, I need to mark 2.2 and I need to use an addendum that says it's going to be essentially contingent on the sale of my property.
Yeah, absolutely. Peter, dealing with this form, do buyer and sellers have to use the UAR form, and maybe why would they want to use the UAR form?
Well, Craig, they'd want to use it because it's a well-crafted piece of art. But do they have to use it? No. And Shane alluded to, so all the attorneys watching can geek out on that. It's lowercase lettering in the REPC. And anytime you see that, it's not a defined term, which means it's not referencing a specific form you have to use. It's identical concept to the seller's disclosures document. You don't have to use the UAR form. However, the work's been done for you. So rather than having to have an attorney go create a separate form that your brokerage could use, this one is there. And, as any form we put together, it's got the collective knowledge of a bunch of brokers and agents and attorneys who have been around in the business for a long time. And as we know, months and months, we've worked on these forms and they've changed a ton. So we think this is a great change to the form. And so that's why you use it. You know, it's a good form and it's the uniformity, right? All the UARs, bank of forms, there's such an advantage to having that uniformity where agents understand the form that is available. They've been taught about it. Instructors know how to teach it, and they're familiar. So that when you get those as an agent, you're not saying, "What does this say? I got to figure out how to divine the meaning of this form." Instead, it's, no, I've been taught about this. I've used this. So there's a familiarity with it as well.
Excellent. So as Shane alluded in the REPC in section 2.2, I have it in blue because this was the newer language that was added in 2018. If a buyer checks that it is conditioned, the purchase of the seller's property is conditioned upon the sale of real estate owned by buyer, then the buyer is going to include in their offer a subject to sale of buyer's property addendum. So let's work through this, Shane. A buyer has indicated in 2.2 that they do need to sell property in order to purchase the seller's property. Let's look at section 1 of the subject to sale of buyer's property addendum. What is just this first section doing with regards to the buyer and their obligation?
So I would view that sort of as almost a notice section, and 2.2 is as well. But basically what we're saying is we're telling the seller that there's a material fact that they need to know about. And that material fact is, I've got a house that I have to sell in order to purchase your house. I either need the cash from that sale, or I can't qualify for my loan until I sell this property because I have a mortgage on that property as well. And so paragraph 1 is giving the disclosure, but it's also telling you what property it is that I have to sell. Is it a property in California? Is it a property in Draper? You know, where is this property? So the seller has not only knowledge that I need to sell a property in order to buy theirs, but also gets even more information as to what that's going to entail. Is this a property that is something that they're familiar with? Or is this a property that's going to be somewhere else where they're going to need more information? Like, it's in California. How hard is this going to be to sell? Or what's going on in California? That kind of thing. So it's giving the knowledge that we think a seller is going to want and need in order to evaluate the offer that the buyer has written.
Yeah, and this is especially pertinent in a seller's market where a seller is evaluating multiple offers and potentially multiple offers that have this condition as part of it. And so it is a way for the seller to evaluate and to weigh the respective offers. So the buyer clearly identifies, I have to sell this property wherever it is, and they identify the property in section 1. Now, this is a key change, and I'll turn it to Peter in 1A. So the buyer's right to cancel before the due diligence deadline or financing and appraisal deadline, whichever is later. What is section 1A talking about, and how would you explain it or teach it this section?
Yeah, this is good stuff, Craig. I think this is a really good change to the form. So basically, section 1 is laying out with A and B, okay, what does the condition mean? What are the rights gained by either party with this condition being placed on the property? And so we lay out there 2 rights for the buyer to cancel in section 1. Because, I mean, that's what we're going for, right? If buyer's saying, hey, I'm announcing I need to sell this property, okay, what happens if I can't? What happens if I don't? Seller, what are you going to agree to? And you notice it should be somewhat familiar, right? It says buyer's right to cancel before the due diligence deadline or financing and appraisal deadline, whichever is later. Well, any agent who's been doing this for a while will realize the buyer has a right to cancel based off of both of those deadlines or conditions anyway. Yep, that's what we've done. As a forms committee, we've lined up those deadlines with this contingency as well. So The next question is probably asked is, well, then why do we even have this? Well, because it's a little different. It operates slightly differently. And that is, number one, you're announcing, and that's information the seller wants to know usually, is that the buyer is in need of completing a transaction prior to purchasing the next property. So we have there's that announcement that takes place in the REPC. And now we've got this condition there. Now, buyer can cancel based off of by the due diligence deadline or by the finance and appraisal deadline. And the only way it operates differently is, let's say they go past the due diligence deadline and they cancel prior to the finance and appraisal deadline, but they use the subject to sale contingency. Well, now if you have any money in that blank in 8.3 of the REPC, which says, hey, if you cancel, buyer, past due diligence but prior to finance and appraisal, you give up this much money to the seller. Well, now if they use the subject to sale contingency, they're not using that same section of the REPC. They would not forfeit that money. So buyer would get the entire amount of earnest money back, is not losing the money in that blank if there was any in there. So that is a difference right there. That's a different right the buyer has. Then we look at B, buyer's right to cancel after the due diligence deadline or financing appraisal deadline, whichever is later. So if buyer does not cancel prior to the due diligence or financing appraisal deadline and has not closed on the sale, so there's a condition there, right? Has not closed on the sale of the property indicated above, then buyer may cancel the REPC prior to the settlement deadline by providing written notice to the seller. And here's the difference. They're not breaching now. They have a right to cancel, so they're not breaching the contract. So they're not going to get the penalties mentioned in the REPC for breaching the contract. Instead, it says right in here, right? Whereupon earnest money deposit or deposits shall be released to seller without further written authorization from buyer. Seller agrees to accept as seller's exclusive remedy the earnest money deposit or deposits as liquidated damages. So they're limited. So buyer gets the right to still cancel. They still forfeit all their earnest money. So once again, reiterating how important earnest money is or can be in a transaction. So make sure there's enough in there to cover your needs as a seller. But they won't be penalized any further than that. They just give up that earnest money. It's not a breach of contract. They can't be sued based off of that backing out for something like specific performance or other damages.
Right. It really is meant to simplify it. And agents that are familiar with our previous version of this form, there was additional deadlines that we created, and it worked, but it got too complicated and trying to line up all the deadlines in play. So now we made it very simple. There are these existing deadlines in the contract, and the contract's going to flow much more simply. And I do like what you referenced in section 1B. That is the buyer's right to cancel, but it does outline the remedy specified there as earnest money. And I would plug as well that get as much earnest money as you can. And I think many of the transactions now are having much more earnest money. So I appreciate that. Anything else you'd like to add in section 1, Shane, before we move to section 2?
Yeah, I think the comments that both of you made are exactly right, and I think that a lot of the input that we've received from the real estate industry, from brokers, from agents that we've talked to on the legal hotline, with my brokerage, with Peter in Utah County, is that we have a real estate purchase contract that is incredibly buyer friendly. The buyer can get out for due diligence based upon their sole discretion. There's almost no way to claim that it wasn't an evaluation or inspection. The finance section is similar, that they just don't like the terms of their loan. They could cancel based upon that. They don't need a loan denial. They don't need anything like that. And the issue that we were hearing about a lot with the subject to sell, where there were 2 issues. The first was, I don't understand how to fill this out. I don't understand the deadlines. We were having basically open-ended contracts because they would trigger deadlines off of the sale of the property, and then they wouldn't have the correct deadline in there. So we saw the form just used improperly a lot. It was difficult to teach. It was difficult to use. But also it was viewed as being just another way for the buyer to be able to get out of a contract. And now it was a lot of the time running all the way up against the settlement deadline. So we have a real estate purchase contract that skews a strong way to the buyer side, and then a subject to sell addendum that was giving additional terms for the buyer to be able to get out that they didn't necessarily really even need. So what the attempt was to simplify that. And I think we absolutely accomplished that, to make this incredibly easy to use for the practitioners, but also making it so it's more where the seller actually understands that when a buyer is using this subject to sell addendum, the buyer still has stake in the game. The earnest money that the buyer is using, and I agree with both of you, the key is having enough earnest money in here. But once the normal contingencies pass, once the due diligence and the finance contingency pass, the buyer now has skin in the game, and they have to decide early on, am I really going to be able to get my property sold or not? Because if I can't, I'm going to need to cancel, and I'm not going to just keep the seller hanging on until the very end, hoping that I can get it sold. This makes it so the buyer really is going to have to know up front, can I get my property sold? And if not, I'm going to have to forfeit my earnest money if I can't get it done. So it doesn't make it where the seller has all the power in this, but it at least makes it so the buyer has more stake in the game, which I think we were hearing almost universally. That was something that was really important to agents when it came to this form.
Exactly. And especially if this form is used in conjunction with the option to keep property on market time clause addendum, it really does swing the pendulum to a more even plane between the buyer and seller. Excellent points. There was a question, is there a difference between before and by the deadline from a contractual standpoint? The way that I would answer it, before, it just needs to be done before the specified deadline, which is going to be 5 p.m., whatever the date is. By that deadline, I don't think that there's going to be much difference in my mind. Mark, I'll answer your question. I haven't had a chance to read through that, but we do want to get through this form. So Section 2, buyer's property listing requirement. Now, the premise behind this is we do want buyers that are putting offers on seller's property to use a buyer's brokerage. I mean, we want them to use a realtor. We think that there's protection in using a realtor. And we think it's beneficial to the seller for the buyer to have their property listed. So Section 2, Shane, what is the premise behind that, and how would you teach Section 2?
Yeah, so this is, I think, and we had a similar section of this before, but I think we've really strengthened this section now. And that is, we want to tell the seller what the status is of selling the property. Have you even listed it or not? You know, is this property under contract at this time? And we'll get to that with Section 3. But really the key is, have you listed this property or not? But the key difference is, if you haven't, it's going to be listed, and it's going to be listed on a multiple listing service. And the prior version of this form didn't spell out that it would be listed on a multiple listing service. And there became a question of, well, if they've signed a listing agreement with any brokerage at all, and they are trying to get it sold in a closed office listing, they've complied with this. And there was just a lot of wiggle room where the sellers didn't actually know how actively this property was being marketed. And instead, we've made the change that not only is it, if it is, number one, you're going to tell us if it's listed or not. If it isn't, you're going to get it listed, and you're going to get it listed on the multiple listing service. So we know it will be exposed to the most buyers potentially that will be there to try and buy this. So at a minimum, we know you're trying to get this sold. It's going to be on the MLS, and you're going to tell us the name of the brokerage that it's going to be listed with, so we can communicate with them, and potentially before we ever even accept this offer, to talk to them about how active is this, how long do you think it'll take to get a buyer, what's the price point that you're thinking this is going to be sold in. So the seller has all the information necessary, again, to evaluate this. But it also allows for agents that are representing the buyer in this transaction to have the conversation with them. You need to sell your house. Have you listed it yet? Well, we're going to need to fill out this form to say that you're going to list it with someone. Maybe you should list it with me. I don't know. So I think it actually will help out agents as well, that if they have somebody sitting on the fence, using this form is going to help you say, it's time to get off the fence. We got to get going on this, and we need to tell them that it's going to be listed. List it with me. Let's sign the listing paperwork. Let's get going on this. So I think it's going to really help out buyers agents as well.
Excellent. And then section 3, it's just a disclosure. Is the property the buyer has to sell, is it or is it not currently under contract? Again, information that a seller would use to evaluate this offer that's coming from the buyer. So there's a couple of questions, Mark. Again, I'll get to that question, but there's a question here. How can we guarantee that the buyer's property will close by the due diligence deadline or the financing appraisal deadline? Would we just make the settlement deadline on the buyer's property to be 4 days before the due diligence deadline or financing appraisal deadline on the buyer's purchase? Peter, do you want to try to address that one, or should I take an attempt at it?
I can chime in. You can't guarantee. There are no guarantees on these contracts, right? And we hear about all of them that go wrong all the time. And so you make your best guess, but the job of the agent with this form is to help the buyer understand the protections that are in there for the buyer. So at some point, and there's another question that kind of alludes to this in the comments as well, is like, what guarantees do you have? You don't. I mean, what guarantees do you ever have with the buyer that they're going to qualify, that they're not going to go buy a Ferrari with a giant loan 5 days before they're supposed to close on their home loan? You don't have all these guarantees. So you are still putting your faith in a buyer, but at least you have information now, right? At least you have an idea, and Shane just walked through all the listing information that you now will have of how serious are they, have they progressed in the attempt to sell their property. And then buyer has the decision. I mean, they're going to have to time this right, and they're going to have to look at it. At some point, a buyer may take the risk, right? A buyer may say, well, I'm not going to know till after my finance deadline whether or not this actually closes, because we delayed a little for buyer's buyer. And we're hoping they come through with that VA loan or whatever, and maybe they don't. Then buyers needs to be aware that if they cancel at that point, they are forfeiting their earnest money. So by no means is this risk-free, and has this guaranteed to a seller that you will absolutely get this transaction done. This buyer will make it happen, and you will know if they won't. You're still going to have to wait until settlement to know if that buyer got everything to come together. But is it that different than any other transaction? You still don't know until settlement if that buyer is able to pull everything together. So no guarantees. But you got to help that buyer understand the timing and what's at risk, because if they go past that finance and appraisal deadline, all their earnest money is at risk. As a seller, if I'm representing a seller, and let's say a buyer really wants to use this, and you decide this is a good buyer, maybe it's the best option we have, I'm going to make sure there's enough earnest money in there to make it worth my time as a seller, because I know it's a slightly higher risk transaction. It is. So you got to have enough in there that's going to keep that buyer honest and will compensate you, so that if 60 days, 45 days down the line, you get to settlement and that buyer bails and uses this condition and says, you know what? Yeah, I went past all my other deadlines, but my buyer bailed and I didn't have to notify you of that. No, you can look at the listing. You can keep track of this as an agent, but let's say something surprised you and their buyer didn't come through, and it was 4 days before settlement on your property as a seller. Well, you have enough earnest money in there to compensate you for that trouble and having to start over. So that's the idea. No guarantees.
Yeah.
Craig, can I add one thing to that as well?
Sure.
The other thing to think about is this is not a provision that says a property is required to be sold by a specific date. This is a provision that says what happens if it isn't sold by a specific date. So in other words, we've set the due diligence deadline as the finance deadline as the last deadline for the buyer to be able to cancel if their property isn't sold. It doesn't say it has to be sold by that deadline. It's just the last deadline that the buyer has to be able to cancel if it's not. So the buyer can absolutely run their settlement deadline on the sale of their own property up against the settlement deadline on this one. There's nothing that prevents them from doing that. They just have to know they are now putting their earnest money at risk once the normal contingencies of due diligence or finance have expired. Now their earnest money is going to become non-refundable at that period of time. And so they should be thinking about that when they go under contract on their own home. When is the earnest money on that transaction going to go non-refundable? Do I have enough to cover if that transaction fails? Do I have enough earnest money coming to me on that one to be able to cover this one? It makes it so you need to think about the multiple transactions together, but this doesn't say it has to be sold. This is just the last deadline you have to cancel if it's not. And you absolutely can run your settlement deadline up against the settlement deadline in this one. You're just telling the seller at that point, you're going to get my earnest money if I can't get my property sold.
Yeah, and frankly, Shane, this isn't a new concept because, as Peter alluded to in section 8.3, the financing condition, there already is a provision for the buyer having the right to cancel after the financing and appraisal deadline. And it specifies that the seller's exclusive remedy, if the buyer fails to get a new loan, would be the earnest money. And so this is just going hand in hand with that provision that's already in the contract that maybe sellers don't necessarily realize. And so hopefully realtors can help educate. And that's, again, another proponent for having additional earnest money. And I think a lot of these kind of concerns about, well, does the buyer have the capacity or the capability to perform, can be addressed to a degree with the revisions that we've made in the time clause addendum. So the time clause addendum, it's been used for many years. I mean, if you look at the form, it was first introduced in 1998. I mean, so we're talking over 20 years this form has been in existence, and there's been various iterations, and it definitely has served its purpose. And so based on feedback on the hotline, we've made some tweaks, and I do think it is beneficial that we talk a little bit about some of the things we did not do to this form, because that is a lot of the feedback that I sometimes get on the hotline of components of this form that they wish were part that we did not include. And so we'll maybe chime in about that. But let's start first with section 1A and B. So first, starting with 1A, Shane, we did make a minor tweak here, and maybe you can talk a little bit about 1A and then also about 1B, and then we'll go through kind of 1B a little bit.
Sure. I think you and I, Craig, and Peter as well, have had questions as to the time clause addendum, and this interesting question that we would get is when the seller accepted another offer and essentially would accept it in a backup position, sometimes they didn't want to trigger the time clause. And the language in the last version of the time clause could have been read to indicate that they had to actually trigger the time clause, which didn't make sense for anyone involved in it. The buyer generally doesn't want the time clause to get triggered. The seller is the one that would normally be dictating, is this offer good enough where I potentially am going to push this, my primary buyer out? And there were questions as to, did the secondary buyer have the ability to force the seller to trigger the time clause as well? And so what we wanted to do with the change to 1A is just make it clear, this is totally up to the seller on whether or not they want to trigger the time clause. If the seller wants to accept a backup offer, but wants to stick with their primary offer because they still think that's the strongest offer, they can do that and not trigger the time clause and let the buyer continue to have their contingencies and not force them to decide whether or not they have to remove their contingencies or allow the contract to be canceled. So that's the main change that we made to 1A, is that the seller may notify the buyer in writing of an accepted backup offer, but they don't have to. That's totally up to the seller to decide if they want to do that or not.
Yep, exactly. And then Peter, in 1B, maybe just that first paragraph, what anything changed in there that you would want to reference?
So this will look very familiar, right? It has the conditions, but a change that may be largely cosmetic, but because we don't like to do math anymore and add hours, and instead we put days. So you notice in the blank, the buyer shall have blank days, which we can't call it the 48-hour time clause anymore. I don't know.
72.
So that was a change, but that's significant. That's not insignificant, because the way hours function in a contract versus days is somewhat drastically different. I mean, you start a stopwatch with hours, or that could be the mindset is, okay, you have, 32 and a half hours from right now, and it's, the diehard countdown clock, and something bad's going to happen when that thing hits zero. Now we've got the days, which now goes to a function of, all right, it starts the day after, there's a deadline, it's 5 o'clock, it's kind of a preset. Be a little more familiar to most agents than like, wait a minute, did we send that text over at 3:30 or 4:30? Do they have another hour? None of that anymore. And then the conditions. You notice the boxes: due diligence, appraisal, and or finance, and if applicable, subject to sale. A lot of debate on that last one. Should we keep those together? Should we lump them, or should we do them separately? We decided those would probably go well together. In form, it's a moot point anyway, because we lumped those dates together. So largely it doesn't, I mean, I guess it matters, but because that subject to sale can continue after and give them rights to cancel after that financing deadline. But those are lumped together, so be aware of that. And then notice that it's an and or concept. So you can check 1, 2, 3 of those, any combo, and they'll all apply.
Yeah.
That's kind of it with that section. Anything else?
No, I mean, that's the main premise. I mean, combining these two, that's a pretty big deal. And we'll get into 1C, because I can already kind of see a little bit of the commentary on this. And what happens, Peter, if a buyer does want to remove the due diligence condition, or the appraisal, or the financing and subject to sale of buyer's property conditions? They want to move forward. They love the property. They want to remove. They're willing to take the risk there. What does 1C do?
Yeah, it puts a little more skin in the game, right? It gives the seller the option to require that, I should say, or I guess a buyer could just offer it to make this look attractive. But yeah, it's the same concept that we've always had built into the REPC of additional earnest money, but we're putting it in this form. So it's up front and center, and the seller or buyer can offer and say, hey, I would like to add some additional earnest money. If I'm going to give you, if I'm going to continue on with this transaction, and seller perceives maybe I'm taking a risk by doing that, then here's what it's worth to me as a seller to allow you, buyer, to remove the condition and continue on. But you can see, by eliminating the conditions, seller is contractually guaranteeing if this thing goes south, they're going to get X amount of earnest money. So it's just a way for a seller to build that in, to say, all right, here's my protection, because we just went through all the ways that a buyer can take risks still in not knowing whether this transaction is going to close. And so this is, again, one extra layer besides the base earnest money for a seller to say, okay, I would like a little more earnest money on the line. And it also, I guess, helps the buyer have that conversation of, how serious am I? So seller's got another buyer, potential buyer. They're triggering this time clause. I'm agreeing to remove these conditions, and I'm going to pony up more earnest money. So how serious am I about eliminating seller's next best option and continuing on with me? How serious am I about going forward with this?
Excellent. So Shane, kind of going with that same scenario, let's say a buyer decides, yes, I'm going to remove all my conditions of purchase. I'm going to remove it. I'm going to put an additional $5,000 of earnest money, and they still have to sell their house. They still have to get a loan, but they remove the conditions. what risks is the buyer taking at that point?
Well, now the way that we've structured this is the buyer is risking their earnest money. And we've built in basically a mechanism for the seller to require more additional earnest money. Because the problem that we were hearing from the time clause was if the earnest money amount wasn't significant, and the buyer hadn't sold their house, they could essentially just roll the dice on this and see if they could actually get it sold. Hope that they could get their loan done. Hope that still try and evaluate their due diligence. And there was no real risk on this. So C was just to try and beef up the time clause a little bit. It's optional. They certainly don't have to put in that more earnest money will be used. But basically you're going to remove your contingencies, but in addition to that, you may have to put down more earnest money. Now, if it never gets triggered, then the concept would be you don't have to deposit any additional earnest money unless you build that into the contract itself, which you already have a provision to do that in the real estate purchase contract. But this is a separate section just on the trigger of the time clause itself to add a little bit more heat to it from the seller side. Seller wants to know, if I get a much better offer, not only are you going to remove your contingencies, but now we're going to get some more additional earnest money that's in here so that I know you really are committed to performing under the terms of the contract.
Yeah, and realistically, if I remove the financing and the subject to sale conditions and I don't perform, section 16.1 comes into play, which then opens up the remedies available for a seller. Now, I don't know if a seller sues for specific performance when a buyer can't perform because they don't have the financing, but it could potentially open it up for other consequential damages that may result from the buyer's default or breach of contract. Now, I'll ask one more question related to this because we had some good debate and discussion about this specific section. And I have iterations with this section different. Ultimately, we're going to get the question, well, Craig, why didn't the forms committee want to have, or why didn't they include in this form some sort of verification or proof that the buyer could in fact buy the seller's property without having to sell real estate they own? Why did we land on this version rather than having language like that? And what would be your response to that, Shane? What do you think about that?
Well, you're speaking my language because I was a big proponent of putting that in, just so that we would have, from a seller's perspective, okay, you're removing the subject to sell condition, but can you actually buy my house still if you don't sell your property? And I think we would have had language like that if we hadn't changed the subject to sell addendum itself. And the changes that we made to the subject to sell addendum, where the earnest money is now going to become essentially non-refundable when due diligence and finance expires, gave enough negotiating power for a seller. All you really have to do now is make sure you have enough earnest money to make it worth your while to move beyond those and take the risk of whether or not the buyer will sell their property or not. Because really this is all about risk allocation, right? If I've applied for a loan and I'm going to buy a house, there's always a risk I could lose my job. And whose risk is that on? Well, according to our real estate purchase contract, the risk is on the buyer. We don't have anything in there that says if the buyer loses their job, they can get out of the contract. They're going to default and they may not be able to get their loan. And so those provisions take place. This was the same thing. The way that we've dealt with this is, where is the risk allocation going to be? And now it is, once you clear due diligence and finance, the risk goes to the buyer where they're going to lose their earnest money if they can't perform under that. So based upon that, we didn't feel like it was necessary to have language in this to state that if you remove subject to sell, you have to prove you can buy the house. You can buy my house without selling yours, because the reality is you're probably still attempting to sell your house. This isn't saying that you're not under contract. This isn't saying that that you still aren't trying to sell your house. This is just allocating the risk. And once you remove these contingencies, you've now changed where the allocation of risk goes, and it goes directly to the buyer. Whereas the seller just knows now, if they don't perform, these are the options that are available to me. So it just changes the allocation of risk.
Yeah, and the seller's going to be weighing that risk level as well. that's where they can certainly put pressure with 1C and hopefully the initial earnest money deposit. Now, 1D, certainly the buyer doesn't have to take that risk. Maybe they say, look, I don't want to put additional earnest money in it, and I don't feel comfortable removing these conditions. 1D describes what happens if the buyer just doesn't remove those conditions. And some of you correctly noted, I do see your comments there that there was a version that talked about section 1.2. You'll notice right here, it has the correct version, and that's been updated on our website. We can have numerous people look at it, and then I'm glad that everyone's reading through this form because many people have noticed that. So it has been corrected. So notice 1.B. So if it's not removed, then the REPC will automatically cancel. And then what happens to the earnest money? It gets released back to the buyer. So the buyer gets to weigh that analysis. So the other kind of aspect with this is, well, how does the buyer notify the seller that they are removing the conditions of purchase found in 1.B? And that's where we do have a new form that does this. And again, some of you noticed we have right here 1.B, we did make that correction. So really, this is a pretty simple form. I'll just delve into it real quickly. It just references the addendum that you used, the option to keep house on market time clause, and then you go ahead and you use 1.B there, and you give notice to the seller within the time frame there. Once you do that, then you're good to go. I'll look to see if there's any other questions that maybe we haven't answered. This is great feedback here that everyone's kind of giving. Any other concerns or thought that you guys would want to chime in before I start throwing out some questions?
I have it's not really a concern, but it's a thought, and that is that this notice form that you just showed, it is a notice and is not a part of the REPC. Now, could you add it, throw it on the back? It's not going to be the worst thing if you do. But the notices are separate from an addendum. A notice is triggered by an event or a requirement in the contract, and it satisfies that with a written notice. But the actual contract, the part of the contract that would remove the contingencies is that addendum. That's the option to keep property on the market. So in that addendum, it points out that if a notice is received, then it triggers the removal. And we had some discussion about that in the forms committee of why is that notice not an addendum? And do you have to then separately amend the contract as a buyer and say, yes, I agree to remove these conditions, contingencies, and send it over? And then what if the seller doesn't accept it by the deadline? And so I think as forms committee, we landed on, no, this time clause addendum acts as the amendment to the contract that removes those contingencies when that notice is sent and received.
Yeah, and any sort of notice needs to comply with section 18 of the REPC, and that's going to be defined right there, where it's in writing, it's signed by the party giving notice, and then it's received, and then just needs to be received within the time frame. And in this case, it's whatever days written in section 1.B of the option to keep property on market time clause addendum.
The notice part, I mean, we talked about whether or not it should be an addendum or not. And we saw a lot of problems before we created this form where it would be done in an addendum, but then they would also include language where they changed another provision that would get countered, and then the parties would start negotiating. And then it's what Peter said. It left this question of, well, if this never gets accepted, what exactly just happened? Was notice properly given? And we always agreed that, yes, notice was given because the initial addendum that sent over acted as a notice, but it caused a lot of confusion and a lot of calls to the legal hotline that we thought could be avoided, because really what you're triggering is the buyer has a unilateral right to give the notice, and that automatically changes makes the removal of the contingencies, and it has no bearing on what the seller's opinion is at that point. It's strictly up to the buyer to do that. So that's why it's only signed by the buyer. There's no reason for the seller to initial or acknowledge or anything like that. The only key is that it's received before that deadline.
Yeah, absolutely. So we recognize that these are new forms, and it certainly takes some adjustment, and we try not to make modifications just to make modifications, but it is based on feedback, and the feedback we were receiving, especially with the subject to sale, was that it was just too complicated. We had third-party contract deadlines, we had a separate buyer's closing deadline, and it was just hard to even graph and diagram and just keep it straight. So we really were just trying to simplify it, but we also wanted to be a value proposition for realtors that buyers and sellers should use a realtor, that the transaction can become complicated. And so realtors can help simplify while also protecting the interests of both the buyer and the seller. Like Shane and Peter both described today, it's allocating risk. And if the seller is going to accept an offer that has either the subject to sale and or the time clause, then there needs to be some protection for them, or at least they need to have some understanding of the risk that they're taking in evaluating the offers that may be competing on their property. So it's definitely meant to be helpful for realtors. We hope that the changes are helpful. But the nice thing about UAR forms is that we can make modifications pretty rapidly. It's not subject to DRE approval or the Attorney General approval like DRE forms are. And so we do have some flexibility on that. And so we do try to make modifications based on feedback that our membership wants. And so I hope that people know that we are trying to make these modifications to be more beneficial for our members and the clients that they serve. Any additional questions that maybe, or concerns or thoughts, Shane and Peter, as we maybe kind of close this, and I'll maybe type on some of these questions that we have?
No, I think we've gone over the forms and talked a lot about the why. And when we change forms, I think it's always important to be able to answer the why. And the committee put a lot of work into making sure that this was done in a way that was going to make the forms, number one, a lot easier to use, just like you talked about, Craig. But number two, sort of making sure that we are not skewing our contracts and our forms to one side, that we aren't a committee that is creating forms that are only for the buyer or only for the seller, but making sure that both parties are fairly represented in the transaction. And if we have our forms that are too one-sided, it makes it appear that we favor one side or the other. And I think this is a great step forward in the right direction of balancing between buyers and sellers, which is what we always want to do when we create these things.
Yeah, I agree with that. The question of when can these forms become available, we have sent them to our vendors, and we have sent the corrected versions to our vendors as well, with that little typo that we did correct. The correct versions are on our website, and I believe that the various vendors, so the various MLSs, DocuSign, Dotloop, ZipLogix, Instanet, they should be available in the next couple of days or weeks. But certainly look for those, but they are available on our website, utahrealtors.com currently, so you certainly can find them there. Thank you, Shane and Peter. A wealth of knowledge from both of them, a wealth of experience with both of them. And so we're definitely grateful for their input and their contributions to these forms, and certainly in helping explain. And I would imagine they're going to continue to teach these forms and how they interact with the REPC in the next couple of weeks and months to come. So please give us our feedback on how they're working. If we do need to make additional tweaks, we can do that. But we do want to see how they're working, and if there are concerns about any sort of ambiguities, but we really did try to address as much as we could within the form setting. But there's nothing like real life practicality. And so once these get used, we hope that we get feedback on how they're being used and if they are more helpful than the previous versions. Thanks again, Shane, Peter. Thanks for everyone that tuned in. We had a great following, and until next time, take care, everyone. Bye.
Thanks, Greg.